We ask that you bless them.
Okay, thanks to everyone who is on. The report, let me just indicate, of last week and completed 10. So it was circulated Monday evening, and therefore we decided not to have our meeting yesterday, but to have it this. I am aware it's possible that not everyone gone through everything. So what I'm going to do this morning, Kamika, I've members including the second and their need and also visions to look at but in clear as much as all the matters that are in red. It is possible that we could complete them, but if we don't complete all red, Tuesday, the matters in red, which is 20 pages, and probably less after we go through the various decisions in red. So that my great hope is at the end of today we will have completed most of the indeterminate or undetermined or the red issues that need some finalization. And then next week, maybe a meeting or two, if necessary, a third. So to complete a review of the draft report. Even before beginning, I would like to thank Secretary Anila, who worked closely with Kamika and Nadine over the past many days to put together what I, speaking personally, has seen to be a very fairly good, constructive, and all-embracing report. Obviously, there will be changes as we go along, but we hope that this report, this draft report, will present us the basis on which we can complete and make a final report to Parliament. One of the reasons why we should just try to concentrate and get in the red areas completed is that will assist CPC to complete her final draft of all the amendments to be made. Because at the end of the day, my proposal is to indicate to Parliament that there is 30, 40 or whatever number of changes, and we will show Parliament where the changes are in this present bill. But we hope to redraft, to withdraw this bill when we go with this report to Parliament and table the new one with all the changes. So members of the committee, with those remarks, if no one else has any comments, we'll just ask Kamika to take us through all the red.
Chairman, yes. Julian Robinson here. Just before you go into the specific details, did the committee make a final decision in terms of the implementation of NIDS vis-a-vis the operationalization of the Data Protection Act?
This is the very first clause.
Oh, it is. Oh, sorry. My apologies.
That's the very first clause.
Sorry. All right, go ahead. All right, go
ahead. So we will make a decision on that immediately, okay? I don't know if there are other comments. So, Kamika, are you on, Kamika or Anila? I want of you to just read the red areas as we go along. So we start with clause 1. Is Kamika on? Anila?
Kamika is on, sir.
Kamika, would you like to take us through with the immediate, and then the committee can just decide what we do with the red, whether we just keep them or change them as we go along. So Kamika, will you read from clause 1 first, please? The red areas. Not getting her. I'm not hearing from you, Kamika. Is your mic unmuted? All right. Until Kamika comes, let me read that first part, the members of the committee. Kamika, you ready? I am seeing a Kamika, but we're not hearing you. Not hearing you, Kamika. Kamika, we're not hearing you. Kamika is having some difficulty, members of the committee. What the first clause says, your committee notes that clause 1 does not stipulate the date on which the National Identification and Registration Act would come into operation, and in respect of different provisions of the Act, and also expresses the view that whilst it would be desirable for the Act to be operationalized after the implementation of the Data Protection Act 2020, we agree that this would be an administrative decision and therefore would not be our decision. Member Robinson, my suggestion is that we should just leave those as it is. What do you think?
All right, so the concern I would have, and I didn't realize it was the first issue being raised, is that without the operationalization of the Data Protection Act, if you implement NIDS, there's really no protection for all the persons who would be signing up for NIDS. Now, while I know it's not a legal issue, I believe it goes to the heart of the protection of our citizens, and was also something which came up in the court ruling about ensuring that the Data Protection Act was in place before we actually implement NIDS. So I feel very strongly about it because I feel we would almost be flying naked in a sense, and any breaches that would take place potentially, then there would be no redress.
All right,
so,
I agree with you. I don't know if other members of the committee would agree. I think instead of saying it would be desirable, I think we should say that we should make it almost
stronger, make it stronger.
Yeah, a condition precedent.
Yes, correct.
So
no, I believe you would know better because you're in government, but I mean, they've already advertised for an information commissioner, and I believe steps are being taken to establish the office. So I think it would also be important.
From where I sit, then I strongly believe that they're taking steps to implement the Data Protection Act sometime this year.
Right.
And there is correspondence because we have written to the PS, Mrs. Sewell, and she has been in correspondence with PS Palmer about from STEM, Ministry of, Minister of Technology and so on. So basically, I do believe that it's likely that it will come into play. Warren, what's your impression? Have you been getting any indication, Warren, as to when it will come in operation?
Good morning, everyone. Morning again, Chairman. Yes, I believe it is going to happen this year. A lot of steps would have been taken by the Technology Minister to facilitate this. I understand that they would have started the recruitment process for an information commissioner. And I also learned that documentations were submitted to the Governor General for approval. And we are also providing support from the project to make it happen this year.
And so, Warren, what's your opinion? Should we say that the NIDS should come into operation after the implementation of the Data Protection Act?
Chairman, may I intervene?
Sure, AG.
You're asking the question as to whether that is to be stipulated in the bill?
Not in the bill, but in our report.
I see. I don't think there's any disagreement or equivocation on that, having regard to the ruling of the court.
Right.
So I don't know if that is an issue that is even up for debate.
Exactly. So I would
included that we accept it, and that is the recommendation to Parliament.
Right.
Think that all members of the committee are in agreement.
Right. So I would say that we put it stronger, Anila, that the act should only come into operation after the implementation of the Data Protection Act and remove the last line. Is that agreed, colleagues?
Yes, I'm okay with that.
Okay. All right. So if that is so, just change that first, please, Anila. Make a note of that change, and then we can remove the jotteds or the from red. Clause 2. Clause 2 read the red portion. Your committee does not agree to the proposal to change the current definition of identity information as to the existing definition, as the existing definition captures the intent of the policy. I would accept that. What do you say, colleagues? Is that agreed?
I am with you, Chairman.
Agreed, Chairman.
Right.
Agreed as well.
Right.
Agreed, Chairman.
So we changed red to blue, Anila. All right. Kamika, are you back on now? Are you on now, Kamika?
Yes, Chair. Are you hearing me now?
I'm hearing you now. Could you take us then to clause 3 and to explain?
Sorry, Chair, before you move on.
Sure.
There's a portion there in blue that notes that the committee accepts the proposal made by a number of organizations for definition of the term accredited third party used at clause 25. But according to my notes, the decision was not to accept the proposal because clause 25 provides for the process of becoming an accredited third party to be set out in regulations. So there would be no need for a definition there.
That's my understanding too, Madam CPC.
I'm sorry, I should have mentioned that. Yes, I think you're right, CPC. So please, Kamika and Anila, make a note of that the committee notes, but does not agree with the proposals made by a number of organizations.
Very well, Chair.
Okay, so that should be corrected. That blue section should be corrected. And okay, fine.
Okay. As it relates to clause 3, perhaps the Brandon.
Can you bring up the screen, please, so we can clause 3 fully.
Bring it up some more, clause 3.
Well, that's gone now above clause 3.
No, it is clause 3.
Right. Right. So in relation to the proposals regarding identity theft, right, the committee this was that clause as well that I don't know if Senator Braham is on, Chair, but in light of the discussion, we asked that the committee revisit the discussion as to the necessity of the objects clause. Yes, we asked that the committee revisit that because it may be that in the future, the objects clause will not adequately cover what the bill is trying to do or what the policy position is at the time. And therefore, we ask that the committee have a look at that again.
Chairman, may I ask for a deferral of the settlement of clause 3 objects of the report in keeping with, well, 2 things really having regard to the discussion is whether we in fact include the objects clause and if it is to be included.
You're breaking up, AG. We're losing you.
Hearing me better?
Yes, no.
I'm saying, may I ask that we defer a conclusion on this part of the report regarding clause 3 for reasons, among others, to consider whether an objects clause should be included at all, bearing in mind how the courts construe legislation where an objects clause exists. What else should go in it if we choose to keep it, or whether to delete it altogether.
All right, I don't have a problem, AG, but we need to finalize that discussion within the week. So by next Tuesday, we can have a decision on clause 3. Okay?
Yes, agreed.
No problem. Clause, okay.
Clause 4.
Is that okay, other colleagues? We defer clause 3 till next Tuesday. Clause 4.
Okay, Chairman.
Very well.
Yes.
Very well, Chair. As it relates to clause 4, the committee noted the proposal to replace the words ordinarily resident with resident. However, we do not accept the proposal and agree to retain the term ordinarily resident. In relation to the issues on whether a person seeking refugee status in Jamaica would be eligible for enrollment, that was the committee is invited to consider the fact that the refugee, within the current definition, the refugee may very well be able to apply, or the committee could consider the current process and whether or not that will be necessary it will be necessary to indicate or to refer specifically to refugees. With regard to the Ministry of National Security, they reiterate, we were asked to contact that ministry to find out about their policy with regard to this, and they are of the opinion that it should remain as is, and they would actually prefer the word resident, prefer that the word resident be utilized in such a manner that it speaks to to legal status, to someone who is legally residing in Jamaica for at least 6 months, instead of utilizing the term ordinarily resident. On the other hand, the term ordinarily resident is utilized in different pieces of legislation in a manner that is specific to that legislation. And that's what the committee would need to decide.
Any comments, colleagues?
Yes, Chairman.
Okay, after you, Minister Hill.
Yes, Senator.
First one is the refugee issue. I come back to where I was when we discussed this. Refugee issue doesn't come up. You can only apply for this card when you're a resident.
Fine.
Now, if you're a refugee, you go to the Minister of National Security and you get your status established and you become a resident. You then would have to be you then would have to be resident for 6 months. So that doesn't change. We don't get involved in naming refugee in this. You're able to apply for the NIDS card when you're a resident or a citizen, whichever one that you use. Now, ordinary resident or resident, resident as being used here, I think is defined for having lived in Jamaica in a resident status for 6 months. Ordinarily resident seems to be looser. It doesn't matter to me that it was used before. If it was used before and we're doing something that's up to date, we should probably use something that is more specific. And I like the more specific that you're resident here for 6 months. That's my view, Chairman.
Thanks, Senator. I think Senator Donna Scott Motley is trying to get him. Could you, Senator Scott Motley, are you on? Senator Scott
Yes,
Motley.
I am, Chair.
You want to comment, make your
Good morning,
comments?
Chair.
Yes.
Yes, I want to agree about the refugee status. I embrace the expressions of Senator Hill. I would like to, however, inquire of the technical team if ordinarily resident alongside with being used in various pieces of legislation, is not also defined in case law. And whether the departure to make, as Senator Hill suggests, to take advantage of the opportunity might not, is it worth disturbing what has been long used and read and understood? And I see the AG I now see the AG, so perhaps she too can provide some guidance in this regard.
Before the AG provides the guidance, may I add a little point of clarification to my comment? I don't mind ordinarily resident, and even if it's established in case law. What I'm concerned about, Senator Scott Motley, is as we do this NIDS arrangement, it must be very clear as to who has the right to have that NIDS privilege, because it's going to give you a great deal of privilege. And I just want it to be as specific as possible. I wouldn't want to interfere too much with case law, but I wouldn't want case law to limit the specificity that I think is very important to the NIDS card. Thank you.
I understand. I'm sorry. I interrupted you. Please.
No. You finish, Senator Scott Motley. Then EG and SG.
I understand. Yes, I understand perfectly the point that you are making. And it is for this reason that I state that we have over some long period of time, there has been an understanding attached to the term ordinarily resident, not only in other pieces of legislation, but as determined by case law. So that if that is pellucid because of how it has been interpreted, does it need to be changed? No. Because when you put it in, putting it in this legislation as resident, as distinct from ordinarily resident, might lead to a different interpretation from what you really intend. So that is why I'm asking the technical team to guide us, because they would have.
Maybe you could tell me what ordinarily resident means in case law.
Senator Hill, I think we'll ask AG or SG to bring us up to date, because I know the term ordinarily resident.
Is chiming. Go to the SG first until it's done, please.
All right, SG, can you bring us up to date?
Good morning, Chairman and members of the committee and colleagues. Senator Scott Motley is correct that there have been cases that have interpreted the term ordinarily resident. However, those cases are usually more the tax cases, because that is generally where you would have seen the term originally in tax laws, and so it's usually interpreting the use of the term in our tax laws. And so the cases have focused on the interpretation of the term from the tax perspective. What we have done in other pieces of legislation is modeled the definition from those same tax laws. So generally then the case law would assist because we have generally kept the same formulation and wording as used in tax law. And the meaning is what you have here, meaning how it's been defined. It's clear. So what you have in the bill, that is usually how it is used.
AG?
Yes, Minister. So as the SG has indicated, the ordinarily resident is more or less a term of art. And when we are referring to residency as a criterion for eligibility, it is usually stated as such. And the legislation would define it accordingly, give its definition. So while I appreciate what Minister Hill was directing attention to, I do believe that ordinarily resident is the appropriate term to use to capture eligibility for persons who would apply by virtue of residency. That's one.
Then may I ask Chairman to explain to me what does ordinarily resident mean in case law and how you practice it? I need to understand that.
Right. So first of all, it specifies a period of time that a person is within the jurisdiction with a certain level of attachment, as it were. But it also has regard to the fact that people may be in and out for various reasons. So as opposed to permanent residence, I think it is used in contrast to permanent residency. Ordinarily resident, you have made somewhere your home, even if you have another home elsewhere, but there are sufficient attachments to that place to create rights and obligations.
Right. My understanding, Senator Hill, is that we normally don't use the term resident by itself because we have terms like temporary, ordinarily, and permanent resident. So usually ordinarily resident, my understanding, and AG or SG can correct me, it usually refers to persons who would reside in a country for about 6 months for the year, or up to 6 months for the year, as against permanent resident, where you would have had to reside in the country for about 5 years before you're considered a permanent resident. And so, is it so, SG?
So, Chairman, yes. I mean, like I say, it is now regarded as a proper term of art where residency is used as a criterion for either a right or an obligation.
So the position, Senator Hill, as the lawyers have been trying to point out, is that if you use the term resident, it would be ambiguous in that persons may not know whether you're referring to permanent or temporary or ordinary resident. And that is why—
all right, here is my issue.
But Chair,
here is my issue.
Chair, Senator Hill, could you permit me to add something before you comment?
Go ahead, Senator.
Because I would like to direct your attention to how ordinary resident is defined in the legislation.
That's what I'm trying to find.
Because it says that you have resided in Jamaica for a continuous period of not less than 6 months, immediately
Senator
preceding
Motley,
the date of application for enrollment.
Senator Motley, that's all I've been asking for. A specificity that I can understand. Otherwise, I could easily say to you, somebody came in here a week and ordinarily resident could technically apply.
You had seen the definition.
One second. What Senator Motley has just read,
yes,
as to explaining what that means, that you have to be here for 6 months, fits my requirement.
Immediately before, yes.
Yeah, because you can't just get that thing because you've been here 3 weeks.
All right. In relation to the refugee matter, so yes, let's be reminded what we're seeking to do. The legislation provides enrollment criteria, a primary enrollment criterion, and that is bifurcated: citizens of Jamaica and persons who are ordinarily resident in Jamaica. It is an opt-in system, but for persons who opt-in, what the government is seeking to do is to be able to know persons who are within the borders. So if you notice, our Charter of Fundamental Rights and Freedom speaks to persons who are in Jamaica, right? So you have rights that accrue to citizens of Jamaica, but for the most part, it's persons who are in Jamaica.
Right, but what Senator Hill is mentioning, the AG, those persons should really be assessed by the immigration.
Coming to that, right. So a person does not acquire refugee status just like that. You go through a process. And the the end of the day, a determination is made. And once that determination is made, entitlements flow from that. I agree with the perspective that if you are seeking to opt in on the limb which says that you are a resident in Jamaica, and ordinarily a resident in Jamaica, and in order for that to be lawfully determined, you have to go through a process. Naturally, it stands to reason that the issuance of a card would have to await the outcome of that process.
Right. So,
right. But I think we also have to clarify whether or not, as a matter of policy, we would want to open an application to someone who is in the process of determining or having a determination as to whether they would be an ordinary, lawful, ordinarily resident person in Jamaica.
And you see what?
But that, right? No, I'm totally with Senator Hill. I understand what he's saying. That goes through a process, and let that process be done. I'm just saying, bear in mind what the NIDS is seeking to achieve for persons who opt in, what it is enabling and knowing within bounds, so that I can see a government wanting to know persons who are within its jurisdiction, so that when it has to make allocative decisions, for example, it can efficient.
The point
that's not hard, Chairman. That's not hard at all. If the Minister of National Security should be able to tell the government, we have 25 people looking for.
Well, there you go. And your answers, and that's an answer to that question. That's an answer to the question. That is perfectly fine. So that this would not be the only place through which the government may ascertain who is within the borders, because we will have persons who are going through processes and are awaiting determination. Fine.
So the real issue though, AG, should the NIDS bill take into account persons who are refugees, or should they come under the category of ordinarily resident?
So again, Chairman, so we know that the eligibility is on a two-prong basis. So if you either fall in one category or the other.
Right.
You have to go through a process to determine which category, then you await that process, because persons may also be applying for citizenship.
Exactly.
Means available under the Nationality Act, pursuant to Chapter 2 of the Constitution.
So the real point, though, that we are trying to make a decision on, we won't deal with refugees in the Act, or should we deal with refugees in the Act? Senator Hill is of the view we should not refer to refugees.
No, I think we decided that the last time we met with the Prime Minister. That was decided. You will come in as an ordinary resident, as was defined, or a citizen. While you're applying for whatever else you're applying for, refugee or citizen or whatever, you have to wait till that process comes in. When you get into one of those two categories, you can apply.
Okay. So I think the conclusion or the consensus, members of the NIDS committee, is that we won't refer to refugees. You'll come in via, after you have been assessed by PICA or whoever assessed persons applying, and they become ordinarily residents. Okay? And is that okay, Kamika? Kamika and Anila, so the position is that we're going to stick to the position you have to be ordinarily resident as defined. Kamika, are you with us?
Yes, Chair.
So is that clear then?
Yes, Chair.
And in relation to the second part, my understanding is that we agreed that diplomats would not be included, save and except if they're Jamaicans. Colleagues, could we hear from you? Read that third section. Your committee notes the queries, the necessity of clause 4.3.
Well, Chair, okay. And then can we go back up a bit? So your committee notes the queries of the necessity of clause 4.3 with regard to persons claiming privileges and immunities under the Diplomatic Immunities and Privileges Act not being eligible for enrollment. The clause, your committee agrees that the clause will be retained in its current state, but for the indication that citizens, that persons who are Jamaican citizens, though they are diplomats, they will still be able to apply. Chair, though, there was still some concern with regard
to a point of order. Yeah, a point of order. I don't think that's relevant either. You already said the person is a Jamaican citizen. A Jamaican citizen, whatever else they are, whether they're an athlete, a diplomat, a banker, or a lawyer, can apply.
That is correct. But once they're a Jamaican citizen, they can apply to the rest.
You don't have to bring in diplomat at all.
Well, Senator Hill, the bill specifically excludes persons who may be able to exercise immunities and privileges under that act. And there is actually a schedule that may be created under that act. There's a schedule which may be created to indicate Jamaicans who may exercise those immunities and privileges in Jamaica. And so those two clauses, those two sub-clauses may very well conflict.
But Kamika, once the person is a Jamaican,
that's it.
They can apply. The fact that there are diplomats to be excluded from the NIDS bill, in my view, they're mutually exclusive. In other words, they apply on the basis that they're citizens. The fact that they're diplomats, it should not affect the fact that they're Jamaicans. Okay? So because they're applying on the basis that they're citizens. Okay? So I think I agree with Senator Hill. Colleagues, do we agree that, I mean, as far as we're concerned, once they're citizens, they apply. No, it is a fact that there are Jamaicans here working as diplomats, and therefore they apply on the basis that they're citizens. Okay? So I think we can't exclude them. You see, we would be ignoring the fact that they're citizens if we exclude them. You see, so and that would be, they could go to the court on the basis that they are citizens of Jamaica. All right? The fact
Chairman,
that
I don't understand why this matter is up for debate.
You're quite right.
I understood the need for discussing it, but a person is a citizen of Jamaica, is a citizen of Jamaica for as long as you're
full stop.
current. And so if the criterion for opting enrollment is on the basis of your citizenship and you're a citizen, it really doesn't matter if you have other things with the citizenship.
Absolutely. So we clear that up.
And remember that constitutionally, if you obtain citizenship by birth or descent, you can never lose it.
Absolutely.
Our constitution says in chapter
and Chair.
Yes, Senator Motley.
Chair, let me add, my own view is that a Jamaican is not entitled to the immunities and privileges under the Diplomatic Immunities Act.
Exactly.
As a Jamaican.
In Jamaica, exactly.
So that in Jamaica as a Jamaican.
Can't be a diplomat in your own country.
All right, thanks again. We can move on. So you do the necessary changes, Kamika and Anila. No, clause 5 and 6. I think I understand what you.
Chair, there was something further up in clause 4 with regard to the query as to what would occur when a person is no longer ordinarily resident and whether it should be addressed in the legislation.
I'm not too sure we need to address that. The likelihood is that when they're no longer ordinarily resident, they may well return the card or they may well disappear. The fact is that that NIN remains with them, almost as if they had died. That's my understanding. So if they're no longer ordinarily resident because they came here for a couple of years, they left, they should, in my view, return the card. But if they have not returned the card, they live abroad, they may well return again, you know, after a period of time abroad. So I am not too sure we need to deal with that, Kamika. The fact is that they were ordinarily resident when they applied for the card. Okay? All right.
Chair.
So that's my view. Now, 5 and 6, because of the various changes that have been made in terms of the governance structure, perhaps CPC, you could tell us what will be in clause 5 and 6 next Tuesday, because I think that's the main point that we're making in regards to 5 and 6. Isn't that so, Tamika?
Sure, yes.
Right. So based on what have been discussed, I know CPC may have a draft, but perhaps for next Tuesday we could put in the draft for consideration. Would that be okay, CPC?
Yes, Chairman, I've already done the draft.
Yes, but we would like to see it, Anil and Kamika, for next week, Tuesday's consideration. Okay? All right, so that's 5 and 6.
Ms. Cunningham has her hand up, Chair.
Sure, Ms. Cunningham, go ahead.
Sorry, good morning. I was just confirming for my information, was it then agreed that 4.3 is to be deleted? Because that's what I was trying to see, where it says the necessity of 4.3.
CPC, what's your
according to my notes, Chair, that provision was to be retained. It had to do with the issue of the person still being able to verify that there was no information about them in the database.
So that the opinion then is that we should retain 4.3.
Thank you.
Okay, thanks. Okay. All right, clause 7, Kamika.
Right.
Kamika.
Yeah. Yes, Chair. So the committee noted the proposal to remove clause 7 and to limit political interference, and the committee needs to just indicate whether it accepts or doesn't accept the proposal and agrees that the clause should remain.
Well, basically, speaking for myself at the moment, I see no reason to remove clause 7. There must be a minister responsible for the needs, and whether they're interfering politically or otherwise will be determined by the commissioners when they report to Parliament. If the commissioner believe that the ministerial directions are too political, they can so report to Parliament. But it seems to me that virtually all commissions must be attached to a minister. The executive cannot be completely severed from any of these various agencies in the country. So that, yes. So let me just finish. So even though you have the Integrity Commission, you have the Indicom, I have never interfered with Indicom, but basically I have to deal with the executive when it comes to Indicom. It is the same with the Integrity Commission. It used to be with me, it is now with the Prime Minister's office, and it is the same with the political ombudsman. All of these commissions do have connection with various ministry in the executive. So I see no reason to interfere with clause 7. That's my opinion. Yes, AG.
You know, I think perhaps there is some ignorance and or misunderstanding about the role of a minister in legislation. And it is true that we have numerous examples of unhealthy interference, and we have seen the consequences of improper partisan politicization of our institutions. But that aside, I think we have come a long way, even though we have a long way to go. But I'd like to say to those who perhaps don't fully appreciate what a reporting or a general direction in respect of policy and inserting a minister's role in legislation, where that comes from. So just by way of reminder that the Constitution provides for a cabinet which comprises the ministers of government, and the cabinet is the chief instrument of policy and is collectively responsible to the parliament for the policy decisions, so that every and any administration that is in place has a policy direction that it is going in. And there has to be a proper place for guidance to be given in relation to the direction that the government is going in. So I hear this talk, and let me just say that while I fully appreciate the legitimate concerns about our struggle, we are still a young democracy. We have made a lot of strides, but a democracy is premised on free and fair elections, which put people into positions. And we cannot continue or join in with a chorus of cynics that continue to delegitimize the elected directorate.
Right.
Even while we work on issues of concern. We cannot say that we subscribe in a high way to principles of democracy, and at the same time, at every opportunity, we seek to delegitimize the democratically elected persons and our institutions. So I just want to put it on the record that, you know,
right.
It's a process by which we get there. And once you have arrived there, you may dislike what is there, but bear in mind that there is a process and it is quite a proper place. So I do not share the view that the provision is to be removed.
Well, I agree with you, AG, but can I hear from the other members? The point is that I would like a consensus, or a majority, on what is the position. Because what I would want is for those red, the red to be put into blue on the basis that we do not accept the proposal. Okay? Yes, Senator Hill.
As you know, Chairman, my position is very clear and very similar to the AG's, and strongly so.
Minister Smith, Senator Donna Scott Motley, Member Julian Robinson, can I get your position? Senator Scott Motley?
I don't feel very strongly about it, Minister. In fact, I'm leaning towards the view which has been expressed.
Member Robinson?
I mean, if we're saying it operates in a similar way to the other commissions like an INDICOM or integrity, then I don't have an issue. Really.
But that is generally how they do operate.
Yeah. Yeah.
Right. Any other comments? So the position then, Kamika and Ella, is that we put it as you have there, but the committee does not accept the proposal. Okay?
Chair.
Agrees that the clause should remain as is. All right? So the consensus basically reporting to Parliament. Parliament can say otherwise, but the position is reporting to Parliament that we leave the clause as is and we do not accept the various proposals. Okay? So that's clause 7. In terms of red, the next one is clause 10.
Yes.
Is that correct? I mean, Kamika, I think the next one is.
Yes, sir. That's the next, yes, on page 8, I believe.
You just,
right. So your committee notes and agrees with the recommendation to the decision that needs to be made is whether clause 10.4 needs to be amended to make provision for the inclusion of individuals who may otherwise be unable to enroll due to their circumstances. These individuals include the elderly, persons who are physically infirm, and persons with disabilities. The details of the framework would be outlined in regulations. However, clause 10.4, we note that that power does exist at 10.4, but there is a concern that because we note that the power to make the regulations does exist at clause 10.1. However, the prescription, it does indicate that that power seems to be prescribed to just those who are described in section, who are at 4 and 5, and therefore we don't wish to have a situation where it would be ultra vires that power to prescribe regulations for additional persons. So that was brought back to the committee's attention to see whether or not an amendment was necessary. A general catch-all phrase.
My view on it is that since it can be dealt with in the regulations, and therefore, if subject to comments from members, we could put this red into blue, and it would indicate that the framework would be outlined in the regulations. The other consideration, though, Kamika, is remember, when we table this report, we want the regulations to be tabled around the same time too, the draft regulations. So at a very minimum in those regulations, the framework that we are referring to here should be in the...
Yes, Chair. Yes, but the concern wasn't really that the framework would be inserted in regulations. The concern is whether or not the power exists to actually speak to these persons, or whether, despite the fact that regulations may be prescribed, the detailing of eligibility for persons with special considerations or rather results in us not being able to then go and make regulations for persons who are not actually stated, or for groups who are not actually detailed in the regulations. And the suggestion is therefore to insert a catch-all phrase to address
my understanding is that there may well be persons who are disabled, unable to get registered, and in the regulations we want the NIDS secretariat to be able to go to those persons to have them registered. Isn't that the understanding, Kamika?
Yes, Chair.
So what we're putting in the regulations, if in fact you have an elderly person who is bedridden, you're not going to ask that person to come to the office or to even mobile units to be registered. Provisions will have to be made for the secretariat.
Chairman, can we look at the clause? Can we, I find it probably a little more helpful to look at the clause while we are...
Sure, I have no problem with that. Yes.
Concerned, so that 10 just a minute, please. So 10.1 says that an application may be made to the authority in such form and manner as may be prescribed and subject to the provisions of this section for enrollment of an individual who is eligible as described in section 4. And then we have further, so section further round. So section 4 is the section which speaks to the eligibility by virtue of citizenship and ordinarily residency. And then we have at sub 4 of 10, an application for enrollment of an individual who is referred to in 1 may be made on behalf of that individual by if the individual is under the age of 18 years, the individual's parent or guardian, or 2, where the individual is in the custody of a facility for the care of children, the officer in charge. So that's in relation to children. And then B, in the case of an individual with a mental disorder, as defined in the Mental Health Act, the nearest relative of the person determined in accordance with Section 3 of the Mental Health Act, and the information required to be provided under subsection 2 shall be treated as having been provided to the individual if it is provided to that applicant. And then it speaks to where the individual is inmate of the correctional facility. My understanding is whether there is to be a specific provision in relation to other disabilities.
Right. So
that is so, then having regard to the fact that we have spelled out other things, you may want to make a reference if it's not covered.
Right. So the question I could ask of CPC, could we have a sort of residual clause or all-embracing clause where we say that assistance would be given to the disabled person to be registered? In other words, that is what my understanding is, where in fact it's not necessarily that the person is not able to register him or herself, but because of disability, they're bedridden or they're in a nursing home, as the case may be. And in those situations, the whole context is, how do we get them registered without disturbing exactly where they are? So they may be in a nursing home. Is it possible we have the regulations, or we put in the regulations, that the Secretariat can take steps to go to a nursing home, for example, to have persons there registered? Aren't those some of the considerations which we were looking at, Kamika?
Yes, Chair. We just want to ensure that the enabling framework is present in the bill. So we brought it back to the committee. So, AJ, I don't know, I mean, it may well be that we have a sort of clause, not necessarily, not only for mental health or for penalized or institutionalized individuals, but for those persons who are not in those categories, but may well be disabled or unable to, or may need assistance.
Well, maybe Chairman, is anyone who chooses, I'm speaking not in the drafting terms now.
Mm-hmm.
Anyone who chooses to opt in, qualified by virtue of citizenship and residency, but may have difficulty enrolling because of any disability that they may under, for assistance to be provided to them. I think that is really what we are.
Right. CPC, could you have a look at that first, please?
Chairman, those, in my view, are matters that can be adequately covered in regulations.
That was my thought.
Yes, these specific provisions in 4 are there because they go to the heart of consent. These are people who are not able to consent, but in terms of persons who have disabilities, there's nothing affecting the consent. It's just a matter of the logistics of assisting them. And those
That's
are
the explanation, yes.
Regulations would cover.
So the point then is that we would put the red now into blue, Kamika, and we note some of the details in the regulations to assist persons who are voluntarily registered but are unable because of disability to apply or to come and get registered, that assistance will be given by the Secretariat. Okay?
Yes, sir.
All right. The last part, I think we had agreed, yes, in clause 10.7 to remove subsection C. As we had indicated, I remember this was brought about by and was being questioned by Senator Sinclair on a previous occasion. So I think there was an agreement that we recommend the removal of clause 10.7C.
Right, Chair. But in going back through, it was pointed out by LRD that perhaps we have now removed, well, that's 10.7c was to address a situation where the individual enrolls or attempts to enroll in the NIC with the intent to commit fraud, which is not actually addressed by B and D. And therefore, if we remove C, we may be removing an important provision.
CPC.
Why wouldn't the matter of fraud be covered by B?
Exactly.
Okay, so it was, okay, so the mischief to be addressed would be just the enrollment or attempting to enroll and not actually necessarily obtaining the use of the card, but the enrollment itself or the attempted enrollment with the intent to commit fraud. Whether or not they obtain the card is a different.
No, it was pointed out by CPC last time to Senator Sinclair that Interpretation Act.
No, but that was an attempt, Chair.
Right.
What we're saying, right? Okay.
But knowingly or knowingly enrolls. If they knowingly enrolled and it was fraud, if they're doing some more than once, Jamaica, wouldn't that be fraud and therefore
Yes,
covered by B?
Right, but
would that not be covered by A? Because would they be giving yeah, that wouldn't that be covered by A? Because they would then not be giving the correct information in order to obtain a duplicate enrollment. I really don't see why what C would add that's not covered there by any of the other provisions.
Well, I believe it was with the intent to commit fraud itself and not just to obstruct or mislead the authority. Perhaps Ms. Wilkins would like to provide some further clarification.
Nadine, you have a concern?
Yeah, thank you, Kamika. The thing is, the fact of seeking to be enrolled more than once is what we're talking about. And I don't believe that it is captured in A, with respect, Judith. And it is, I don't know that there's harm in keeping it. If it needs further clarification, we clarify, but I don't think it hurts for us to be able to prosecute someone for the mere attempt to enroll. And that is the most that I can say on it. I'm not sure why there is violent opposition to it.
Well, I think there might be some harm if you take out the element of not making a false statement or misleading the authority. You could have a case where a person was enrolled by somebody on their behalf when they were a child, and they might not have been aware. And then they might not, well, I guess they would know. But to me, it's just redundant based on what is in A and I think D. But no.
No, D is dealing with loss or destruction. They're all nuanced, CPC. That is the thing.
Well, no, when I meant E, I had renumbered it based on the deletion of C. So sorry, I said D, but I meant E.
But that is to provide false information in order to impersonate an enrolled individual. They're all nuanced.
Yes, I'm saying, but I'm saying collectively with A, B, D, and E, what is there that is not, what would C capture that is not already covered in any of those?
Mr. Chairman.
Yes, Senator Sinclair.
If the application form for enrollment had on it a statement which a person would be signing to on the application form to say that they have never been enrolled before, would cover the situation that we are discussing. I had raised it because the issue, whether we should keep it because of the use of the word, the attempts to enroll, but that was clarified by PPC, and I accepted the explanation that they are given having regard to the Interpretation Act. But what we are discussing could be captured if on the application form for enrollment, it has a statement which the individual applying would be signing to on their application form to say that they have never been enrolled. Then it would then be captured in A, because
that they're enrolling for the first time, that this is their
something
first.
to that effect on the application form. And then if they proceeded, then they would be providing false information.
Exactly.
No, but what about the person who is re-enrolling?
What?
The person who is re-enrolling, who canceled enrollment, or their enrollment was canceled and they are re-enrolling. They're not necessarily re-enrolling with in order to commit fraud, but validly enrolling.
It seems to me there's duplication, Nadine. I think.
But then why would, I'm sorry, Minister, I'm sorry. Yeah. But why would anybody prosecute somebody who is lawfully re-enrolling? I don't know I'm
no. If they're lawfully enrolling, there could be no prosecution. So the point is what CPC is saying, and I must admit, I agree. There's no need to have clause C, because it's, as we have put before, it is covered by B and E. In other words, once you knowingly enroll in a situation in which it is clear that you're trying to deceive the NERA, then I think B and E would capture it.
Minister, I don't honestly, respectfully, sir, don't agree. But I believe Senator Sinclair's point is well taken, that a statement of truth and a statement that you had not previously done it with any fraudulent intent. A statement can certainly be inserted on the form, so that it could actually be dealt with in that way, and just you can be prosecuted merely on that statement if it turns out that you were not honest.
Okay,
when
so
you asserted that. So I accept that that's a way to deal with it, sir.
All right, what we can say is that we will accept the first sentence, and on the second sentence, Nadine, Kamika, and Anila, we indicate a recommendation that on the form, something to the effect that the application is made for a first time or no previous application has been made. Okay? So the second sentence would be the committee recommends that on the form should be words to the effect that the application has no application has been made before, or something to that effect. I'll send it to Sinclair.
Chair,
okay.
It would more be that they are not currently enrolled in
exactly. Something to that effect. Okay, just recommendation 2 in the report to Parliament.
Very well,
so put that, you can put that back into blue, all right? And then the next one, Kamika, is 11.
Right, Chair. We're asking if 11 and 12 could be deferred, such that in order for us to actually present that list to accompany this suggestion. The next team will be submitting a list indicating the...
You want deferral of 11 and 12?
And 12, right. Thank you.
So the next one is clause 16.
Right. Right, and this, Chair, was with regard to the proposal to insert similar penalties for clauses 9, 10, A and B to clauses 16, 10, and 11. The committee had agreed to a fine, and the suggestion from the LRD is that there should also be a custodial sentence at the parish court level. And 1610 and 1611 refer to 1610 refers to someone who willfully tampers with a national identification card. 1611 refers to someone who takes possession of an improperly obtained card or takes possession of a card that they know is counterfeit.
No, and I can agree with that. In other words, no problem. What you have there in 16, we can change to blue. So the recommendation is as suggested.
Clause 17.
Okay.
Okay, this was not put to the committee at the clause by clause review. This was something that the MNS and the JCF had spoken to in the recommending that an offense be created where the national identification card is not utilized in the manner that's specified in 17.1. The response of the NIDS team at that time was that they did not support this recommendation. And at that time, the committee had gone with the recommendation of the NIDS team, but it hadn't been dealt with in the clause by clause review. So for those purposes, we're just asking for the committee to formally indicate whether or not they accept this recommendation.
Members of the committee, could you have a look at that, please? Have a look at clause 17 and also what is being suggested here.
Right, so clause 17 indicates that speaks to, my apologies, the use of the national identification card. And 17.1 states that an enrolled individual may use the card for any of the following purposes: as a means of proving that individual's identity, and as a means of facilitating transactions between that individual and any other party where agreed between that individual and the other party. So what the recommendation is saying, if the individuals attempt to utilize the card in any other manner, which is outside A and B, it should be an offense.
And the penalty you're proposing is
no,
not only...
we don't agree that it should be an offense.
You don't agree that it should be an offense?
No, because if we do that, we may be criminalizing opportunities which are quite valid for using the card in unique manners, in other ways, in innovative ways, which are not necessarily unethical or illegal, and in fact, as the card usage may, increase over time, innovation may develop, and we believe that inserting an offense of that nature would stifle that and stifle the ability for the card's usage to expand over time.
So the position then is that you want it to remain as it's 17.
Yes, Chair. We believe that.
Don't add any additional things.
Right. The other offenses we believe are adequate to address any misuse of the card, any illegal use of the card.
Can I ask a question quickly, Minister?
Sentencing there.
All right. In 17.1a, it allows for the card to be used as a means of proving that individual's identity. There's a situation which exists from practical terms where persons, for example, wants to put themselves up as a surety and they have to establish their address. Is it that this card, NIDS card, can be used to establish address? The address of an individual.
I'm going to ask Mr. Vernon to speak to the technical manner in which that could be done.
And
okay.
Because it is not, Mr. Vernon, before you go on, because it is not facilitated in 17.
Okay, that is a very, very good question. What I can comment on is that we are capturing an enrollee address. And at some point in time, we will be required to verify the address. So therefore, we see no reason why the card can't be used to confirm someone's address. And if there's a weakness in the bill concerning this, then it's something that the committee, should consider to resolve.
Okay.
On that, Mr. Chairman, before you go on that concern that Mr. Vernon just expressed, a provision somewhere could be stated that in the event of a change, and I believe it exists in respect to driver's license and in the Road Traffic Act, that where you change your address, you have a duty to cause the amendment to be made or the information. So if we could put in a provision like that and place the onus on the person who changes address to update the NERA of their change of address, is something that, with a penalty, of course, probably could capture it. Because what I find in practical terms is that persons always have these issues. They have to provide some type of cable bill, electricity bill, or something else.
I understand that, Senator Sinclair. So let's, my initial response would be to agree that it should not, does not accept the recommendation. But could we leave it for some further consideration? All right, so that other members can have a look at it. That's
yes, Mr. Chairman.
17. My suggestion at this time, because quite a few members have indicated that they have to go, is to conclude now and to say to members, next week we're hoping that 3 mornings that we have allocated to look at this report, that between now and Tuesday, members would get to take the opportunity to really examine 420 pages. We should go through fairly quickly next week, but when we meet again next Tuesday, we will just continue to complete the red insertions, and then immediately and hopefully next Tuesday go back to sign off on the various pages. Certainly, I'm hoping that members will be fully informed of what is in the report on each page, so that once we've signed off on the red and we can go back page by page, then members can alert as to areas on each page that they need further discussion or they need clarification. But we're hoping that during the course of next week, that all members will have read and digested what the Secretariat and the NIDS Committee have put in this report, and we can finalize sometime next week. So I know there's another meeting at 10 o'clock, which is within another few minutes, so that I will conclude at this stage, because I've got information that quite a few members would like to leave to go to the next meeting. So thanks again, members of the committee. I think we've started on this report, and therefore we're hoping that by next Tuesday, members will be more au fait with all the thoughts and recommendations. So thanks again, and can I have a motion for adjournment?
So moved.
Thanks, AJ. And okay, thanks again, everyone.
Thank you.